Thank you. Mr. Mintz.
Morning, Your Honors. It's still morning. Going last, I guess my mission is to try to say something that my colleagues haven't talked about, and I hope to be able to do that. I want to start with something that I was going to end with, which is what we think this case is about. We think in 2011, the legislature believed that the indefinite suspension of COLAs was reasonable and necessary. Nobody's been talking about reasonable and necessary. That reasonable and necessary determination by the legislature is subject to judicial review. The appellate division remand would permit that process to begin. The state asserts that in 2011, the legislature didn't construe the contractual right to embrace COLAs. Well, there's simply no basis for that statement. The legislature could just as easily have thought that there was a non-forfeitable right to base benefit COLAs into a whole lot of other benefits, which I'll discuss in a minute, but that given the fiscal concerns about the pension system, it was reasonable and necessary under the Contracts Clause analysis to suspend the COLAs. Should plaintiffs prevail on remand in showing and convincing the trial court that the suspension of COLAs was not reasonable and necessary, the appellate division gets to revisit that question. Ultimately, this court gets to revisit that question. Should plaintiffs ultimately prevail even before this court with a determination that it was not reasonable and necessary for the legislature to suspend COLAs, then the legislature subsequently, if circumstances change, could enact another piece of legislation suspending the COLAs or changing the COLAs, and that too would be subject to judicial review under the Contracts Clause. So the idea that we're here today saying that, the suggestion being that if you find that COLAs were part of the non-forfeitable right, that automatically COLAs will be restored in perpetuity is just not the law, as you well know, and that we think that reminding ourselves that there's a reasonable and necessary test and that the legislature believed that it was reasonable and necessary to suspend COLAs gets us to a little bit different place. I want to address some of the concerns that were raised previously. Justice Patterson and the question about ambiguity. We believe that the question of if the court gets to the point where they decide that the legislature intent was ambiguous, that the tie goes to the state, we agree with that. But that's a determination to be made at the end of the process, not at the beginning of the process. It's not a question of whether or not the statute's plain language is ambiguous and then you end the discussion. It's after if you were to determine that the plain language was not crystal clear and then you looked at the legislative history, et cetera. At the end of the day, if it's ambiguous, yes, then it doesn't meet the unequivocal standard. I'll give you a hypothetical.
You're not suggesting there's any difference between that something could be ambiguous and if it were truly ambiguous and not, and yet somehow get over that hurdle of an ambiguous expression of legislative intent.
I mean, I think if at the end of the day it's ambiguous, we lose. But I think if at the end of the day it said benefits program and it didn't exclude post-retirement health benefits, and the sponsor statement said this benefits program, which of course doesn't include post-retirement health benefits, the state would be here today saying post-retirement health benefits are not part of the non-forfeitable right because it was in the sponsor statement. And I think this court would look at that, properly look at that, and not just at the words benefits program. Justice LaVecchia, we are not arguing that before 1997 the COLAs were protected by any statutory right. That it's the non-forfeitable right that was adopted in 1997. Judge Cuff, you asked questions about the protection of COLAs The state's position is that COLAs are not covered by the non-forfeitable right, and that the only protection for COLAs is a portion of Chapter 78 that says COLAs shall not be reduced, that people who are already getting their COLAs won't have those COLAs reduced. But that could be repealed because that's not protected as a contractual right in the same way that the non-forfeitable right is a contractual right. So yes, COLAs are currently under law protected from reductions, but there's nothing in the state's argument that would prevent them from coming back tomorrow and saying we've eliminated the COLAs even for those who are already getting them.
Your position is that once awarded, that COLA that's been awarded, in a sense, fuses with the basic retirement allowance.
Well, our position is that the COLA is part of the non-forfeitable right, just like the base pension is.
Mm-hmm.
And so,
even when it's an expectation and it hasn't actually been paid out?
I'm not sure I understand what you mean by an expectation. I mean, for those who haven't yet received their COLAs?
Yes.
Yeah. Well, we think that the people who are covered by the non-forfeitable right are people who retired post-1997 and were hired before 2010 when the non-forfeitable right was repealed. I'm not sure what category of people you're talking about.
So you're interpreting the COLA statute to provide an infinite number of increases in application going forward that cannot be cut off.
Well, we know the non-forfeitable right was
based upon your interpretation
repealed
of
for
the
new
non-forfeitable
hires.
right.
So it doesn't go on forever for everybody. I mean, there's a finite number. So I guess I'm looking at the word infinite. There's a finite number of people who will retire who would be entitled to COLAs.
Yes, but let's get to the point. Mm-hmm. If someone's entitled to a COLA, then your interpretation of the COLA statute is that the expectation that it will be paid in 2012, 2013, 2014, in accordance with whatever the payout schedule would be, would continue unabated.
Well, subject to an impairment of that contractual right and an application of the reasonable and necessary test. That's how I started. It may very well be that there are circumstances where the systems just require changes.
Right, but my question is, you view the statute as attaching to the expectation that it will be paid in each and every future year in which it would become due under that statute's operation.
Yes, it's not just limited to COLAs that have already been paid.
That was my question.
Yes. Mm-hmm. Okay. So what do we know? We know that the benefits program cannot be reduced. The legislature said so. We know that base pensions, which the state says are covered, are not specifically mentioned in the non-forfeitable right. State argues they're covered, but they're not mentioned any more than COLAs are not mentioned. There is no list of components. There's no definite. Yes, it would be easier if we had a definitional section that said COLAs, but then we wouldn't be here today. We don't have
we'd
that.
find something to do, but
So this court must try to figure out what was the legislature's intent when it said benefits under the laws. We were talking about plurals and singulars. Laws governing the retirement system cannot be reduced. Plural, laws, plural. Not the law governing the retirement system, but the laws governing each system. So I have here 3.5 pages just in PERS in the, what I'll call the et secs, in the 43:15A-6 et sec. Well, that's the et sec that's listed in the non-forfeitable rights statute in Section 1 that the state refers to that says those are the benefits that are protected. 3.5 pages of benefits that are protected. The state, in its brief, outlines some of those, a half a dozen or more benefits, different retirement systems, different kinds of retirements, death benefits, accidental disability benefits, et cetera. All of those are allegedly covered except COLAs. Well, COLAs are listed in that same list of benefits, 24.1, which Justice Levesque, you've spoken about a number of times. Pension adjustment benefits, payment, funding, liability. It's in there. If you want to ascertain the legislature's intent when it listed et sec, you'd say, well, the legislature looked at all of those things that come within the et sec, and sure enough, there's the COLA. Well, I promised to talk about something that other people hadn't talked about. In 1997, if you looked at 24.1, the COLA section of PERS, what else was there besides COLAs? Post-retirement medical benefits were listed in 24.1, listed within the Section 1 PERS et sec sections. 1997, when the non-forfeitable right was passed, post-retirement benefits were listed right next to COLAs because they both became pre-funded around that time. So why did the legislature specifically exclude post-retirement medical benefits? It had to. Not because of negotiability, not because of the Internal Revenue Code, but because it was listed in the et secs. And if it didn't, there'd be another lawyer here today saying that post-retirement benefits, medical benefits, are included within the et secs, they're included within Section 1, they're included within the non-forfeitable right. But the legislature excluded it because in 1997, it was right next to COLAs as part of the PERS statute, and same for TPAF, et cetera. That fact provides the most plausible explanation for why the legislature specifically excluded post-retirement health benefits. No one suggests that the legislature ever intended to do that. We're not doing that, but they did exclude it. This argument about Article 4, Section 7 of the Constitution, plaintiff interveners were never arguing that the reference to COLAs in 24.1 created the substantive right that ran afoul of that constitutional provision. But if that constitutional provision is at all a concern, I just point the court towards Eggers v. Kenney, a 1954 decision that talked about what's the point of that constitutional provision. It's to suppress deceptive and fraudulent legislation. I don't think anybody's arguing that the decision to pre-fund COLAs and place that in the pension statute was deceptive legislative practice. I want to talk about Section 1, because the state points us to Section 1, points us to this list of benefits. But Section 1, what was the point of Section 1? Section 1 was about making the state pension systems compliant with the Internal Revenue Code, with Internal IRC 401(a)(3), which protects the corpus of the pension funds. Well, what's in the corpus of the pension funds? The monies that the legislature placed into those pension funds for base benefits and for COLAs. The legislature, if you're going to presume anything, you have to presume that they understood that they were adopting a legislation that would protect money that they put into those pension funds for COLAs as part of the corpus. Section 2 deals with IRC Section 415, which sets maximum benefits and maximum contributions. Well, if you look at that law, COLAs are included when you're talking about what is the maximum benefit that an employee can get in a pension. That's base benefits plus COLAs. So for purposes of the Internal Revenue Code, COLAs were treated the same as base pensions. ERISA. We're not arguing, we never argued that ERISA controls public pension systems, but ERISA protects base pensions, and ERISA protects COLAs, and ERISA doesn't protect post-retirement health benefits. And the point of Senator Inverso and what we've argued is that ERISA was just part of our understanding of what the legislature intended and what should be your understanding of what the legislature intended. So when you look at the plain language of the statute, you look at the history of the statute, you look at the sections of the statutes, you look at what was included and what was excluded, you look at the internal revenue sections and how those were applied, and at the end of the day, and only at that end of the day, if you think there's an ambiguity, do we lose. But we maintain that if you look at all of those factors, there's no ambiguity, and that the legislature intended in 97 to include COLAs in the non-forfeitable right. But in 2011, the legislature said, no, we got a problem, and it's reasonable and necessary to impair that contractual right, and there's a process to figure out who's right and who's wrong in that assessment. No questions?
Thank you.